And are you Mr. Shepard, Ronald Shepard, appearing there from the probation department? Your screen is muted. There's a button down in the lower left-hand corner you have to push on, click on. There you go. Are you Ronald Shepard there at the screen that's marked HCPD?
Yes, sir.
Okay. This is case number 23 CR 2027, State of Ohio versus Ronald W. Shepard. This is a hearing that's being conducted by Zoom on a request for motion for continuance filed by defendant's counsel. Mr. Shepard, as I indicated, is appearing from the probation department. His attorneys, Chelsea Panzica and Adam Blyle, are appearing on screen marked Chelsea Panzica. By the way, you're muted, Ms. Panzica. The prosecuting attorney, Annika Collins, is present on behalf of the state. Now, as this is a request, as I indicated, for motion for continuance, Ms. Collins is the victim or victim representative present for this. I'm just omitting somebody named Tiffany Bertram.
That's the victim's mother.
All right. And so she is present. All right. And have you had an opportunity to confer with Ms. Bertram regarding the motion prior to this hearing?
I have, Your Honor. I actually spoke with her before I filed my objection to the continuance
Okay.
and took her thoughts
Okay.
and consideration into my objection.
All right. All right. Ms. Panzica, you wish to address the motion then?
Yes, Judge. Obviously, it is attached to the motion. I'm hoping you got the medical note.
I did.
Fairly filed on and have that be of record.
Sure.
But had I known I was going to be placed on this type of bed rest limited activity, but not scheduled for May 6th. I will say there's been new developments this week even with my medical status that it's going to actually be sooner. So I'm actually going to be ending work, not able to return starting next week. So we are asking for a continuance. I think I've put in here, Mr. Shepard did hire both Mr. Bliley and myself. That's kind of how we work on other cases as well. I'm lead counsel for these trials. Mr. Bliley usually comes on for the trials. Also, it looks like even if we went out to August, we are still within a statutory time frame to have a case tried. So I don't think Mr. Shepard even needs to waive time. However, if that were to make the court more comfortable, he would waive time because he has indicated to me multiple times he wants both of his attorneys there at trial. Also, like I've stated in the motion, I don't know how the state would necessarily be prejudiced or even the prosecuting witness when there was such a delay in indicting anyway. That had nothing to do with Mr. Shepard. So we are asking for a continuance so that both of his attorneys can be present.
All right. Mrs. Collins, we have the state.
I'm not sure why Ms. Panzica thinks this investigation was concluded in March of 22. Our office did not receive the file until November of 22. As evidence, if you look at your discovery, you'll see on the very front page, all items must be completed. There's a stamp that says received November 23rd of 22. This investigation was started on March 10th of 22, not completed. And the victim is going to be prejudiced by this. We're talking about a young juvenile. This is a family member, and she has lost other family members because of this. So this is impacting her life every single day. So to say that she would not be prejudiced is kind of a somewhat callous statement, not taking her feelings and how she's dealing with this into consideration. I'm sorry, Mr. Blyle, did I say something funny?
Ma'am, let's not argue right now on court, okay?
Well, no, you're not going to argue in court, and you don't need to direct comments to counsel or back either way. All right. Do you have anything else, Ms. Collins?
No, Your Honor.
All right. Ms. Bertram, as the victim's representative, you have a right to express your position regarding this matter.
I would not like to see a continuance. My daughter is suffering daily. This is something that she cannot move on from. She's very depressed. She's just having a hard time dealing with it, and she really just wants to move on. And I feel like a continuance is only going to worsen her situation and keep her from healing properly and getting the help she needs and putting us all behind her.
All right, anything else, ma'am?
No, that's all for now.
All right, Ms. Panziki, you have any response?
Yes, Judge, and I understand Ms. Collins' position when they received the case, but in looking through the discovery, the absolute last date that I had that anything was done on this case was March 21, 2022. I obviously can't speak to what happened between March 21, 2022 to when the state received it. I think she said in November, but according to our discovery, there was no updates, there was nothing new. I'm not trying to be callous to the prosecuting witness by any means, but Mr. Shepard was just indicted in February, and I think we need to balance those interests of his right to a fair trial and his right to counsel, both counsel that he chose. They're asking for a reasonable continuance. We're not asking to go out 6 months, we're asking to go out 12.
All right. Well, as far as any delay, the effect of any time passage between the time of indictment and the completion of the investigation, I don't really see that has any relevance whatsoever. The issue here before the court is the whether or not the continuance should be granted. Because of the enactment of substitute Senate Bill, substitute House Bill 343, which is effective on April the 6th, which specifically supplemented the rights that were enacted under the Marsy's Law and Article 1, Section 10A of the Constitution of Ohio. The court's required to consider not just the defendant's rights, but the rights of the victim, which are to be considered. Now, regarding the issue of counsel, if this were simply a short, maybe 3 or 4 weeks or something like that, I could see it being more reasonable, but you're asking for it to be continued at least into August, which is 3 months. And the health situation you have, there's no guarantee that you'll be available then because of the risk, of complications. And so, it could easily be another continuance requested. Nobody knows. Hopefully that won't happen, but that's the situation. You also were aware of your condition when you accepted the engagement. And anytime an attorney comes into a case, they have to be aware of the schedule. And the court has granted one previous continuance to May 8th. We had originally had this set for April 27th. Counsel entered appearance on February the 22nd, so over 2 months prior. This is a one-count indictment for one sexual offense allegation that it's alleged to have occurred in 2021. I don't know how. It doesn't seem to me that it's in terms of complexity being very complex for these types of cases. And that's the risk that always happens when somebody gets a continuance early, and I try to avoid those continuances, but also I try to take into consideration everyone's concerns. But the defendant's right to an attorney of a specific choice has to be balanced against the rights of the victim and the interests of the justice. One of the things that the court will note is that the rule of the superintendent sets a 6-month timeline to complete a criminal case from the date of arraignment. It does provide that if a defendant is unavailable, whether that be for because they're absconded or if they are hospitalized or incarcerated somewhere else, that can be extended. There is no similar provision for the unavailability of an attorney. And Professional Conduct Rule 1.16 provides that if a lawyer's physical or mental health would materially affect their ability to represent a defendant, they should withdraw. So in this situation, we have a young victim. The rights of the victim have to be considered. Again, if this were a short delay of a month or so, I would be more inclined to approve it, but based on the fact that you're asking for 3 months, and again, at least 3 months, and the court does not, feel that there can be you can make any guarantee that you'll be available even then, given the nature of of the reason, of the health issue that you've used or which is the basis of your motion. So, Mr. Blyle is more than capable of representing Mr. Shepard. The court's familiar with him. He's an experienced attorney, and if you're not able to participate, then so be it. Mr. Blyle will be carrying it on individually. So, based upon the factors that I've just mentioned, the court denies the motion. The matter will proceed to trial on that date. Now, let's see, is this the final? Yeah, this is also the final pretrial. Court will note that there was a motion in limine. The states agreed to that, so the court's not going to make any ruling on that. I don't think it's necessary. Anyway, so that matter's taken care of. Are there any other motions that have been filed within the last day or so? Because I don't always get them timely from the clerk.
Not from the defendant, Judge. We did file our reciprocal discovery with that motion in limine as well.
Okay, all right, thank you. All right, now, there was a written plea offer presented.
There was, Your Honor.
All right, and the court's policy, I think both counsel are familiar with the court, but the court's policy is that any plea negotiations have to be completed and entered of record 2 weeks prior to the hearing date, or to the trial date. So right now that would be April, let's see, April 25th, I believe. Yeah, April 25th. That would be a Tuesday. Okay, yeah, it'd be, 2 weeks, or next Tuesday. If there's not going to be a plea agreement, then the court does require that the defendant sign a form that refuses, declines to accept the plea offer, and a copy of that being placed with both the prosecutor and the defense counsel. Has that occurred yet?
No, Your Honor. I'll email that out today.
All right. So if you would email that, and then you'll need to make contact with your client, Ms. Panzica, because if there's not going to be a continuance, or a plea, it's a matter that the court put in after that Supreme Court ruling for the protection of everyone, so that it's clear that a defendant is aware of what the plea offer was and knowingly declined to accept it. And I don't get a copy of it. I don't need to know what the plea offer is. In fact, I don't want to know. I don't want to be informed of that, so that there's no question it didn't have any influence on my decision if a person's convicted later. So that will need to be done. Now, as far as the time of trial for this, Ms. Collins, how many witnesses do you anticipate calling? All right. And I did see the discovery from the defense indicated the defendant and one other person. So, would this be a one-day trial, do you think, Ms. Collins?
I believe it will be.
Okay. Well, we have 2 days set aside, but we start at 8 a.m. With counsel, and the jurors are reported 8:15, and we start picking a jury usually around 8:30 or 8:40. So most of the time these cases can be completed in a day. We usually go into the evening hours with the deliberations. I won't go past 5 o'clock in terms of instructing a jury usually, but we'll just have to play that by ear. Now, any matters the defense would like to bring up?
Judge, I want to remind you, I don't hear that well, and so that's why right now I'm leaning in to make sure I'm catching things. I had a couple of questions to make sure I understand.
Sure.
I want to let you know, when I come into your courtroom, I'm going to try to have hearing aids in. The only thing is, sometimes what they give, they also take. Okay, so I will remind you of that.
We do have devices that we can give you now. We just got some of those in for people that, participants, witnesses, that might need to have some assistance with that. So they're wireless, so we can provide you a copy or one of those and see if that helps any.
We'll figure it out. I just want to let you know when I ask questions.
Okay.
It's not because I can't hear.
Okay.
I had two that I kind of misjudged. The plea, whether he accepts or let's assume he declines a plea, is that to be signed on the morning of trial, or do you want it before it was beforehand? What was the date?
Well, the deadline for a plea is 14 days prior. I would prefer to have that plea agreement, or the form, if there's a refusal or if there's no agreement, completed in the hands of the prosecutor and yourself at that time.
That's fine, Judge. That's real soon. I got one other was, you're talking about times, and I think basically you want to get rolling at 8:15. Do you want us there at 8, or would you like us there before 8?
8 o'clock, I meet with counsel at 8 o'clock, and I'll give you the draft of the jury instructions and proposed jury instructions and verdict form at that time, and discuss any other matters that might need to be discussed. And then by 8:30, 8:40, we should have a diagram of all the jurors, where they'll be seated, the prospective jurors, for purposes of voir dire.
Do you still stream the trials, Judge?
Yes.
And how, do I just access that by calling the clerk's office?
You just go to YouTube and click on Highland County Common Pleas Court, and it should pop right up.
One other. Does your court implement, do you still have any further calls for COVID or anything?
No, we've lifted all those. We are still keeping the jurors seated and not using the jury box. I'm thinking about changing that, but for right now, I think with this trial, we're going to go ahead and continue to follow that. So instead of having 6 people on each bench, we're having 3, but we'll have a diagram that will reflect that.
It sounds like it's a normal jury then. Trial.
Pretty much, other than they're not going to be in the jury box, right?
Right. I got you. I'm with you, Judge.
Yeah.
No, I think that's it.
Okay. Anything else from the state?
No, Your Honor, thank you.
All right, so Mr. Shepard, just again, so you know, the policy about the 14 days, that's a policy I've had ever since I became judge almost 15 years ago, and that is because I don't want to send out and have jurors come in and sit here and then have people talking about settling a case. We don't do that. If we have jurors here, we're going to have a trial. So on the morning of trial, there's no plea agreement. The only thing that could happen is the defendant has to either plead guilty to everything, the state has to dismiss, or we have a trial. Those are the options. So just so you know, and that's not personal, that's my standard policy. It's been in effect, like I said, for almost 15 years, just so you know. So, you know, if you're interested in that, if we're working something out, if you think that's a possibility, make sure you get in touch with your attorneys. I'm sure they'll be in touch with you so that you can discuss whether or not that's a possibility in this case. All right, thank you. All right, is this a list of the schedule?
Yes, sir.
Okay, all right. All right, are you Robert Duell there at the jail?
Yes, sir.
All right, this is case number 22 CR 255, State of Ohio versus Robert T. Duell. This is a Zoom pretrial. Mr. Duell is represented by William Armentrout, who is appearing from his office. Appearing on behalf from the prosecutor's office is Assistant Prosecutor King. Now, Mr. King, I would have to kind of feel our way through this thing with House Bill 343, but is a victim opted in to being notified of these hearings?
Your Honor, we do not have there's not been a form returned by the victim in this case. The state has notified the victim of this hearing, and the victim indicated that they would not be present for the hearing.
Okay. All right. Now, this is a first pretrial. Mr.
Your Honor, sorry to interrupt.
Yeah.
We have also the 2366 case, which is not on for pretrial today, but that case and the case you just called, we do have a resolution. The offer's been accepted by my client, so I think we just need to get with your assignment commissioner, set up a plea date.
All right. Okay. Well, then we'll need to do that, and we'll need to do the 10-day notice then to the prosecutor's office and 7 days to the victim, unless you can get in touch with the victim, Mr. King, and inform the court that they're waiving any presence and agreeing to the matter proceeding without the required notice.
Yes, sir, Your Honor. Okay, does the court want to just set a plea hearing 10 days from today?
Yeah, we'll go ahead and set it. Yeah, let me get to I mean, we could do it earlier if we could get a waiver from the victim, but under the rule, I can, if the parties agree that an earlier time is reasonable, then the court can do that. But one of the things in order to determine that, to make sure the victims have been notified, given the opportunity to be present. So 10 days from today would be April 20, okay, what is next Wednesday? Or no, 10 days, that's going to be on a Sunday, I believe, because today is the 19th, and 29th is on a Saturday. So May 1st would be the first date. I'm out of town May the 1st, so May the 2nd
Grand jury.
in the afternoon.
Yeah, they have that quick little court trial at 1:30.
That what?
The court trial at 1:30 in that Penix case.
Well,
They said it won't take very long.
probably not, because I don't think she's even going to appear. How about 2 o'clock on the 2nd?
What time is that, Judge?
2 o'clock on May the 2nd?
That's fine with me.
Okay.
That's fine, Your Honor.
All right, so this will constitute the 10-day notice to the prosecutor. At 2 p.m. All right, so send out written notice of that for
Please?
for a plea hearing.
Okay.
Yep. All right. Anything else then, counsel?
No, sir.
All right. Then we'll need Stephen Williams next.
He's got another file.
Yeah, it's on both cases. Yeah.
Got it. Yep.
Mr. Butcher's not jail, Judge.
Who isn't?
All the way at the bottom, Mr. Butcher.
Well, we have a female appearing from the probation department. Do we know who that is? I wonder if it's that Pierce woman.
No, she's in jail.
Okay. All right, are you Stephen Williams appearing there from the jail?
Yes, sir.
Well, case number 23 CR 63, State of Ohio versus Stephen Williams, Stephen Michael Williams. This is a pretrial being conducted by Zoom. Mr. Williams' attorney is William Armentrout. Appearing from his office, appearing from the state is Assistant Prosecuting Attorney Adam King. Been charged in an 8-count indictment with various drug offenses. This is the first pretrial. Final pretrial will be on May 3. Trial will be on June 15. I see the state's demanded, or the defendant has demanded discovery, and I do see a bill of particulars has been filed. Has a discovery been filed?
I have it, Your Honor.
Okay.
Not the same, back pattern as the last case. There's been a plea offer, my client's aware of it, he has accepted it. So if we could set it on May 2, right after the dual hearing.
Well, we can do this one earlier because there's not a victim. But, so we could do this one next week if you want to. Actually, I believe I have time tomorrow.
That's fine with the state, Your Honor.
What's your schedule like, Mr. Armentrout?
I haven't gone over the plea form with him, Judge, and we needed to talk about it.
Okay, let me give it the calendar again. I should have. It looks like I'm going to have to keep the calendar here for hearings now with this notice issue. So, but I'm thinking Friday I might have some time. Let's go get the calendar. What's your calendar look like next Friday, Mr. Armentrout?
The 21st, I've got it. We can do it in the morning, Your Honor.
All right, I'm getting a calendar here to see.
I have an 8 o'clock at juvenile, but I don't think it takes very long.
More show on the phone?
She's downstairs, Judge.
Oh, okay. 21st. Let's see here. 8:30, I have an arraignment. Nine o'clock, it looks like we have 3 pleas scheduled, so maybe 10:30?
Yeah, that'd be fine, Judge.
All right. All right, April 21st at 10:30. Thank you. All right, Robert Hopkins, please. All right, are you Robert Hawkins III appearing there from the jail?
Yes, Your Honor.
All right, this is case number 22 CR 195, State of Ohio versus Robert O. Hawkins III. Mr. Hawkins is appearing by Zoom from the jail. His attorney is Danielle Witt, appearing by Zoom from her office. Appearing on behalf of the prosecutor's office is Assistant Prosecutor King. This matter was set for a pretrial, and I have received a plea of guilty form, so this is a drug charge, so we don't have any victim notification issues. Miss Witt, are you and your client both in agreement that this matter can be held by Zoom rather than his personal appearance in the courtroom?
We are, Your Honor.
And are you okay with that, Mr. Hawkins, waive your personal presence in the courtroom?
Yes, Your Honor.
All right, since you are not in the courtroom next to your attorney, if at any time you need to talk with her about the case or ask her any questions, you tell me, and then I can put you and her into a breakout room, and the deputy will leave the room, and no one else that's on the screen no one else will be on the screen or have any ability to hear you, so you'll have a confidential discussion with your attorney, okay?
Okay.
All right, now, I've been presented with a plea of guilty form, Mr. Hawkins, which indicates you're going to withdraw your not guilty plea and plead guilty to the charge in the indictment. Now, this is a documents prepared by the prosecutor's office. I'm going to hold up the face page, the first page, just to see if you recognize that form. It has your name and case number and plea of guilty on there. You see that?
Yes, Your Honor.
And you recognize that form?
Yes, Your Honor.
All right, on page 3, about a quarter of the way down, there's a sentence that reads, I enter this plea voluntarily, and immediately below that is a signature defendant line, and it appears to be signature of Robert Hawkins. And I'll hold that up to the camera and ask if that is indeed your signature there in that top line that's on the page, on the camera.
Yes, Your Honor.
When did you sign this document, Mr. Hawkins?
About 12:30.
Okay. And did you go over it with your attorney and have her explain everything to you and answer any questions you had before you signed it?
Yes, Your Honor.
When you signed it, did you understand it to be a plea of guilty, meaning there wouldn't be a trial and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Do you feel that you were rushed or pressured in any way into signing this document?
No, Your Honor.
And do you still wish to go forward with this agreement?
Yes, Your Honor.
And did you enter into this agreement to plead guilty, and are you entering a plea of guilty today voluntarily?
Yes, Your Honor.
All right, now the agreement states on page 1 that you're going to plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 the High Revised Code of 5th degree felony. States that you understand that the maximum penalty for that could be 12 months in prison. There's a minimum of 6 if prison's imposed. There could be a fine of up to $2,500. There could be a license suspension of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Other than this charge, are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No, Your Honor.
Now, under the law, if you are sentenced to prison, if you plead guilty to this offense and serve a prison term, the law provides that upon completion of the prison term imposed by the judge, adult parole authority does have the option, if they choose to exercise it, to put you under post-release control supervision for a period of up to 2 years under the terms that they set. If they do that, you'll be supervised by a parole officer, and if during the period of time that you're being supervised, the adult parole authority determines that you have not complied with those conditions, then they can return you to prison, even though you serve the entire term set by the court for an additional period of up to half of your prison term, in this case for 1 or more violations. But there is a cap of half, as I said, of your prison term. However, if you're convicted of a new felony while under post-release control, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. What that means is instead of going to prison, you would be put under the supervision of a probation officer under terms set by the court, which could be for a maximum of up to 5 years. And if during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 12 months, fine you $2,500. You understand that?
Yes, Your Honor.
Right now, the offense in this case alleges that on or about April 16, 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of 2925.11. So that's the charge of aggravated possession of methamphetamine, the 5th degree felony with the penalties that I've just described. Now, do you understand what it is you've been accused of by the state, what they said you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
Have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney.
Yes, Your Honor.
And are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you in any way to make you plead guilty here today?
No, Your Honor.
Now, on page 2, about 2/3 of the way down, or 3/4 of the way down, there's two sentences that are typed in bold and underlined that read as follows. Defendant shall utter a plea of guilty to the indictment. State defense jointly recommend community control and star. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not to the parties. So even though there's been an agreement that you should be given probation or community control and star program, that recommendation is not binding on the court. Once I've heard all the information, if I decide that's not the appropriate term, I could impose a sentence of 6 to 12 months in prison. I could fine you $2,500. I could suspend your license for 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
Now, before I can accept a plea from you, you have certain constitutional rights you must understand. First, you have a right to have an attorney, and I appointed Ms. Witt to represent you. Now, that wasn't simply for the purpose of working the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide that you do not want to enter this plea of guilty, that you would rather defend against the charge, she'll continue to represent you, including a trial if that's what you want. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this, or you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that reside in Highland County that are summoned for jury duty on your trial date. After those 12 jurors are selected, the evidence will be presented. They'd be instructed on the law, and then that jury of 12 people would have to decide by unanimous verdict, meaning all 12 of them would have to agree on whether or not the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing, your right to have a jury trial, and in that case, you would have what's called a court or bench trial, which means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to be available to testify if you want them to, even though they don't have to, let me back up. I'm trying to do too many things here at once. Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. Prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. There's a jury trial, and you do not testify. The judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
All right, now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you're not required to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegations and the indictment denied you committed a crime and exercised or invoked all the rights I just described. excuse me, second. In that Shepherd's file this morning, there's a haste questions. Yeah, I didn't mean for it to go back. And then here, would you get that and shred that?
Shred it.
Yeah. All right, so originally entered a plea of not guilty, which denied the allegation, denied you committed any crime, and exercised all the rights I just described. Change your plea from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that there are crime, that you committed that crime. That plea waives, gives up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront the witnesses against you and cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. The waiver gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. The waiver gives up your presumption of innocence because if you say you're guilty, then the state is not required to prove that you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, thank you. You could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Right, now, do you have any questions about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes.
Have any questions about the plea agreement?
No, Your Honor.
You understand that?
Yes.
You understand the recommendation on sentencing is not binding on the court?
Yes, Your Honor.
Do you have any questions about the constitutional rights I've explained to you?
No, Your Honor.
You understand those?
Yep.
Have any questions about the plea of guilty, what it means, what the consequences that'll be if you enter it here today?
No, Your Honor.
You understand those?
Yes.
Is there anything you need to speak with your attorney about before we go any further?
No, Your Honor.
Do you have any questions at all about anything I explained to you today?
No, Your Honor.
All right, and then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the plea agreement that we've just discussed? Is that your decision to go ahead and plead guilty? All right. Then as to the charge that it reads that on or about April 16, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term between 6 and 12 months, a fine of up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. Court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Pleas accepted, ordered filed. Defendant is found guilty of the offense charged in the indictment, fifth-degree felony. Court orders a pre-sentence investigation, which shall include an assessment for substance use disorder and or mental health issues. Bond is continued. Sentencing hearing will be May 18 at 1:00 p.m. All right, is there anything further from counsel? All right, the probation office will be in touch with you, Mr. Hawkins. Thank you.
Thank you.
Oh, wait a minute. Would you go back? I think I left my, that file is out on the counter. All right, are you Nicole Jacqueline Pierce appearing from the jail?
Yes.
All right, this is case number 23 CR 69, State of Ohio versus Nicole Jacqueline Pierce. This is a pretrial hearing being held by Zoom. And as indicated, she's appearing from the jail, appearing on behalf of the state, Assistant Prosecutor King, appearing on behalf of the defendant, Attorney Danielle Witt. And it's my understanding that we have a representative of the victim also present. Is that correct, Mr. King?
Yes, Your Honor, that would be Zachary Barnhart, who is present as a victim's representative for RC.
Okay. All right. Now, this is a first pretrial. The trial or final pretrial set for May 3. We have the trial set for June the 5th. I see that the discovery has been provided, and you did receive that, Ms. Witt?
Yes, Your Honor.
All right. Now, I do have a motion from the state. Well, it's actually titled plaintiff. I guess that's correct. That requests the court to order a competency evaluation under 2945.37B. And you've received that, Ms. Witt?
Yes, I have.
All right. Well, under the statute, the court's required as a matter of law to order that. So the court will order that the Forensic Center conduct an evaluation of the defendant's competency stand trial. I'll also order an evaluation as to the mental status at the time of the alleged offense. We will set a hearing for that. That will, of course, put the case on the inactive docket and hold the time pending that report. And let's see, today is the 19th. So we'll set it for hearing on May the 18th at 2 p.m. Assuming that we get the report back from them. They usually get it back to us a couple of days before order it, but in case it's not back, then the hearing will be June the 7th at 11 a.m. Because that following week I'll be on vacation. And I know that coming back we have some trials and stuff, so that's a Wednesday after I'm back. All right. Any other matters then to discuss at this point from either counsel?
No, Your Honor.
All right. All right. Well, Ms. Pierce, there'll be a psychologist will be getting in touch with you. I don't know if they're going to do it by Zoom or if they'll make a personal visit. They've been doing it both ways, but they'll be talking with you. So I don't know who it is. They will appoint the examiner, and they'll be in touch with you. So you need to make sure you talk with that individual and cooperates, because this will be to help everyone understand what the situation is with you. All right? Anything? All right. Thank you. All right, are you Robert G. Jackson?
Yes, sir.
All right, this is case number 23 CR 54, State of Ohio versus Robert G. Jackson. This is a pretrial being conducted by Zoom. Mr. Jackson is appearing from the jail. He is being represented by Attorney Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Adam King, the assistant prosecuting attorney. This first pretrial, final pretrial set for May 3, trial set on May 11. Now, we have a victim in this case. I do see that there's been a victim impact statement that somehow ended up in this file. I haven't seen it, but it really doesn't belong here. It should be with the prosecutor, so I'm going to have the bailiff give that to, put that in the prosecutor's box, because until such time as there's adjudication, the court's not in position to see that. I don't think that was supposed to be the notification, opting in or opting out form, Mr. King. It says victim impact statement.
Yeah, that shouldn't have happened, Your Honor.
Okay, well, I thought it was a mistake, so there's no harm done, because like I said, I didn't read it. I just saw it just now. All right. Now, is a victim present for this proceeding by Zoom?
The victim is not present, Your Honor. However, she has been notified of today's hearing. She has elected to exercise all of her rights as a victim.
Except she is not going to appear here today.
She's not appearing today.
Okay, all right. Okay, so I see that the state's provided a bill of particulars and discovery, and I see Mr. Kirk's reciprocal discovery. Do you anticipate any pretrial motions, Mr. Kirk?
And not at this time.
And is discovery complete?
It is from the defense. I'm not sure if state has anything else or not.
All right.
It's complete from the state also, Your Honor.
All right. And has there been a written plea offer provided?
Yes, there has, Your Honor.
All right.
And the victim has been consulted regarding that offer.
All right. And you provided that to your client yet, Mr. Kirk?
Yeah, he is aware of the offer.
All right. All right. Are there any other matters to discuss then at this time?
No, Your Honor.
No, Your Honor.
All right. Then we'll see you on May the 3rd, Mr. Jackson. Thank you.
Thank you, sir.
All right. Case number 23 CR 49, State of Ohio versus Kendra Ward. This is a hearing pretrial being conducted by Zoom. Ms. Ward's appearing from the probation department on a screen marked HCPD. The jail just went dark. We do have still some other people out there, don't we? Belita Westenberg?
She's not in custody, Your Honor.
Oh, okay. How about Richard Wilson and Daniel Butcher? You said Butcher's out, right?
He's out.
All right, well, Miss Berger's not here yet.
2 o'clock.
Oh, those aren't till 2, that's why. Okay. That's why the sheriff went dark then, okay. All right. Well, you better text them just to let them remind them of that. All right, sorry about that. All right, now, this is a pretrial being conducted by Zoom. Catherine Hapner is representing the defendant. Assistant Prosecutor King is representing the state. They are appearing by Zoom. Defendant is charged with failure to comply, aggravated possession of fentanyl, related compound, aggravated possession of meth. This is a first pretrial. The final pretrial will be on May 3, and the trial will be on May 11. Now, let's see. Looks like the state provided a bill of particulars, and is there already discovery? I don't see discovery yet in the file. Has that been provided?
Yes, that was filed on April 14th, Your Honor.
All right. And you got that, Ms. Hapner?
I did, yes.
All right. Do you anticipate any pretrial motions?
Not at this time.
All right. And has there been a written plea offer?
Yes, there has been.
All right. Is your
I have
client?
received that, Your Honor, but I need my client to contact me so we can go over that offer.
All right. So, Ms. Ward, you need to get in touch with your attorney. You want her to stop by on her way home or call you or something?
Yeah, she can stop by on her way home.
All right. So stop when you leave probation, go down to her. You know where her office is here on North High Street?
Yes, sir.
South High Street?
No, North High
No.
Street.
North High Street. I've got my directions. I don't know what's going on. Okay. I didn't ask, but is there a victim in this case, Mr. King? Anybody injured or any property damage? All right. Okay. Anything else then we need to discuss at this time?
Not that I'm aware of.
All right. All right, then go see your attorney as soon as you leave the probation department, and we'll see you back on the May the 3rd, then probably by Zoom. All right, thank you.
Okay, thank you.
Okay. Case number 23 CR 44, State of Ohio versus Belito Westenberg. This hearing is being conducted by Zoom. Mrs. Westenberg is appearing from the probation department on the screen marked HCPD. Her attorney is Catherine Hapner, appearing from her office, and appearing from the prosecutor's office, Assistant Prosecutor King. The defendant is charged with counterfeiting, a fourth-degree felony. This is the first pretrial. Final pretrial is on the 17th of May. Trial is set for June the 12th. I don't see there's been any discovery requested in this case. Ms. Hapner, have you filed your request?
I prepared it, I intend to file it yesterday, it'll get filed today.
Okay, all right. So there's not been anything exchanged then at this point. Do you anticipate any pretrial motions?
Not at this point, Your Honor.
Okay.
There has been a plea offer provided, Your Honor.
I did get the plea offer, I did go over that with my clients.
Okay, defendant does have that, okay. All right, anything else we need to discuss then?
No, Your Honor.
All right, Mr. Westenberg, then your next hearing will be May the 17th, so you need to go there to the probation office again for that, unless we tell you to show up in person, but it'll probably be by Zoom. Thank you. All right. CR 37, State of Ohio versus Richard Wesley Wilson. And you're Richard Wesley Wilson. There on the screen is marked shock volt SV55.
Yes, Your Honor.
All right, Mr. Wilson, this hearing is being conducted by Zoom. His attorney is Sarah Barger, appearing by Zoom. Also appearing is Assistant Prosecutor King. Mr. Wilson is charged with aggravated trafficking and aggravated possession of methamphetamine. This is the final pretrial. I have been presented with a plea of guilty form. Before we go into that, Ms. Barger, you and your client both in agreement that this matter can be conducted by Zoom without his appearance personally in the courtroom?
Yes, Your Honor.
You all right with that, Mr. Wilson?
Yes, sir.
All right. Mr. Wilson, I have this plea form that's been provided by the prosecutor's office, or prepared, I should say, by them, and it has your name and case number, and it says plea of guilty. I'm going to hold this up to the screen. Make sure you recognize this form that I'm going to be talking about. Do you recognize that?
Yes, sir.
All right. Now, this is a 3-page form, and on page 3, there's a line about a quarter of the way down that says, I enter this plea voluntarily, and right below that appears to be the signature of Richard Wilson. And I'll hold that up to the camera and ask you if that is your signature there.
Yes, sir.
When did you sign this agreement, Mr. Wilson?
I believe Monday.
All right. And did you go over this with your attorney and have her answer any questions before you signed it?
Yes, sir.
And did you understand that it's an agreement to plead guilty, which means that if you plead guilty, there won't be a trial. The next step in your case would be a sentencing hearing?
Yes, sir.
And do you think you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
And you still wish to go forward with this agreement 2 days later?
Yes, Your Honor.
All right. The agreement says you're going to plead guilty to count 1, which is aggravated trafficking in methamphetamine under 2925.03A1, a fourth-degree felony. States that you understand that the maximum penalty for that could be 18 months in prison. Minimum prison term, if one is imposed, is 6 months. There could be a fine of $5,000 and a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction at this time?
No, Your Honor.
Are you currently on felony probation, community control, parole, or post-release control from any jurisdiction?
No, sir.
Under the law, Mr. Wilson, if you should be sentenced at any time to prison for this offense and serve that prison term, once the term is complete, the Adult Parole Authority has the right under the sentencing law to put you under what's called post-release control supervision for a period of up to 2 years after you complete the sentence. Now, that's up to them whether they do it or not. It's not mandatory, but they will make that decision. If they do, You would be supervised by a parole officer under the terms they set, and if during that period of time they determined that you had not complied, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. That means that instead of going to prison, you'd be supervised by the probation department under terms set by this court for up to 5 years. If during that period of time that you're under supervision, they determine that, in their opinion, you are not compliant, they would file a written notice alleging that with the court. There would be a hearing. You would be entitled to have an attorney at that hearing. If the outcome of that hearing was that you had not complied, then at that time the court could revoke your community control and then sentence you to prison for 18 months and fine you $5,000. Do you understand that?
Yes, sir.
All right, now, under the indictment, it alleges that on or about July 21, first count, I should say, that on or about July 21, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1. So that's the charge that, of aggravated trafficking that we're dealing with here, with the penalties I just described. Now, do you understand the charge, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of those charges, the possible defense, possible evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
All right, now on page 2, there are several lines printed in bold and underlined, which I will read at this time. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State and defense shall jointly recommend community control of substance abuse treatment. Defendant agrees to pay back by money to the task force in the amount of $220. Defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Right now, under the law, Mr. Wilson, the matter of sentence is up to the judge, not the parties. And so, even though there's an agreement as to what the sentence should be, if you plead guilty, I'm not required to follow that recommendation. I could decide after I've heard all the information submitted that that's not the correct sentence, and I could sentence you to prison. Do you understand that?
I understand.
All right, now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in Ohio?
No, sir. I'm working on trying to get my driver's license back.
Okay, well, that's not applicable. I'm just talking about, it sounds like if you were a vet tech or a pharmacy tech or
No, sir.
teaching assistant or high school coach or something like that.
No, sir.
Okay. Now, you have certain constitutional rights you must understand before I can accept a plea of guilty. First, you have a right to have counsel. Ms. Barger was appointed to represent you, not simply to work the case out, but provide any defense that might be available to you under the law that you would like her to provide. So if you decide that you do not want to do this, that you want to defend against this charge, you'll still be represented by counsel, and she'll defend you, including a jury trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Wilson, which means that 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury on your jury duty on your trial day. After those 12 were selected, they would be the jury. They would hear the evidence, be instructed on the law, and then that jury of 12 people would have to decide by unanimous vote, meaning all 12 of them would have to agree, as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence and applying the law and making a decision. The judge would be the one who would hear the evidence, apply the law, and make the determination whether the state proves your guilt. Do you understand that? Yep, we've lost you there, Mr. Wilson. Ms. Berger, can you send him a text and ask him to
Yeah.
log in? Tell him to close out and log back in. While we're waiting on him to log back in, let's go ahead and do Mr. Butcher's case. Mr. Butcher, if you would go ahead and start your video, please. forget where I was on the rights. I think on cross-examination. All right, Mr. Wilson, can you hear me now?
Yes, sir, I'm sorry, the phone must have lost service or something.
Yeah, it did, apparently. All right. I was on the explanation of rights, and I believe that I was talking about cross-examination. The law provides that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. And after the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination, purpose of which is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
And as I said earlier, just make sure we got it, is that you do have a right to a jury trial in which 12 people would be chosen from a group of citizens that live in this county as summons for jury duty on your trial date, and they would then decide after all the evidence is presented and they're instructed on the laws whether the state proved your guilt. And it would have to be unanimous, all 12 would have to agree. If you didn't want to have a jury trial, you could have a court trial, which means that you would have the judge hear the evidence instead of the jury and make that decision. That would only happen after you had waived your right to a jury trial in writing. Do you understand that?
Yes, sir.
And you understand that you have a right to confront the witnesses against you in open court and cross-examine through your attorney?
Yes, sir.
All right. Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order called a subpoena, and that forces those people to come to court and be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court and testify against you. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even mention it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of this charge until proven guilty by the state on every essential element of the offense charge. So, the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally entered a plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. Change your plea from not guilty to guilty. That is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits the crime, that you're the one who committed that crime, and that plea waives, gives up all the rights I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But without exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and to cross-examine for your attorney, waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It also waives, gives up your privilege against self-incrimination, or your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
Yeah, no, sir.
You understand that?
Yes, sir.
All right, do you have any questions about the plea of guilty, the consequences of that, what it means if you enter it here today.
No, sir.
Is there anything you need to speak to your attorney about before we go any further?
No, sir.
All right, this is your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of this agreement.
Yes, sir.
Then as to the charge which alleges on or about July 21, 2022 in this county, Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, violation of Section 2925.03A1, the charge of aggravated possession of methamphetamine, a fourth-degree felony, carrying a possible prison term between 6 and 18 months, fine of $5,000, and possible license suspension of 6 months to 5 years. How do you plead?
Yes, sir.
All right, guilty?
Yes, sir.
All right, the court finds on this day in open court, defendants advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept and order file. The defendant found guilty of this offense, set forth in the first count of the indictment. The second count is dismissed. Court will order pre-sentence investigation under the same bond with the same conditions, which will include the report will include an assessment for substance use and/or mental health issues.
Your Honor.
All right, the report will be prepared by probation department, including an assessment for substance use treatment. And your sentencing hearing is June the 7th at 9 a.m. All right, now you need to get in touch with the probation department, Mr. Wilson, so you want to call Mr. Arzima this afternoon, okay?